Morning, Your Honors, and may it please the Court. My name is Dylan Zinzer of the Knox County Bar. I'm here on behalf of the appellant, Mr. Ronald Eugene Fox II. I'd like to reserve 5 minutes of time for rebuttal, subject to Your Honor's approval.
Certainly.
Your Honors, in this case, there are 4 issues presented in the appellate's brief. The first issue related to sufficiency of the evidence for premeditated murder. The fourth issue related to the applicability of the cumulative error doctrine. As to those issues, issues 1 and issues 4, we'll rely on our brief for that, and we don't seek to address those in argument today unless Your Honors have any specific questions as to those issues. The appellant's argument today will focus on issue 2 and issue 3. Issue 2 is whether the trial court erred in denying the defense's second motion to continue. And I know Your Honors have the briefs and you've read them, so I won't belabor the point, but I do believe that a brief recitation of the timeline of these events is important for the court's analysis. So Mr. Fox's case, it was a grand jury presentment that was indicted on January 27th of 2022. The case did not originate in General Sessions Court. I was trial counsel in this case, and I was appointed to represent Mr. Fox on June 23rd of 2022. Around that time, it may have been on the arraignment date, the first trial date was set in this case in January of 2023. So our initial trial date was about 7 months out. As I indicated, I don't know if I mentioned it, but I was appointed to represent Mr. Fox, and I also think that that's an important detail in this case because what had happened is during the course of trial, during the review of discovery, there was some digital forensic evidence that was present in this case. The state of Tennessee had performed an extraction on Mr. Fox's cell phone. They did not perform an extraction on the victim's phone, Miss Davison, and the record reflects during a trial testimony the state couldn't explain why an extraction wasn't done on Miss Davison's phone. But in any event, there was an extraction performed by the state on Mr. Fox's phone. But the specific information that came from that extraction, it wasn't an entire global extraction of the phone. What was presented at trial by the state of Tennessee, it related specifically to location data and certain message and telephone call data between Mr. Fox and the victim, Miss Davison. So as appointed counsel in this case, I sought to retain the services of a digital forensics expert to help me perform my own analysis of Mr. Fox's phone and analysis of Miss Davison's phone. And so trial was set after the January trial date was continued. We were set for trial on May 1st of 2023. And in April 4th of 2023, the defense filed its second motion to continue. And in that second motion to continue, I explained to the trial court the difficulty in finding a digital forensics expert to assist in Mr. Fox's case, and specifically the difficulty arising with finding an expert who would work for AOC funding. That was addressed with the trial court during that motion that was filed on April 4th. On March 17th of 2023, the state had also provided us with supplemental digital discovery. And so we had the initial discovery disclosure in that case, and then March 17th of 2023, less than 2 months before trial, we received more digital discovery. And at that point in time, I was still without my own expert to assist me with that process.
When was the initial cell phone material provided by the state? What was that date?
I would have to refer to the technical record, Judge Wilson. I don't remember off the top of my head, but I can say as a matter of course, if I was appointed in June of 2023, it probably would have been
June of 22?
Or I'm sorry, Your Honor, yes, June of 22. It would have been sometime over the next month or two. I know that the technical record will reflect when the motion, the defense's discovery motion was filed and when the state's discovery response was submitted.
All right, so shortly after, let's say July or August, sometimes within a couple months after your appointment, you get the limited digital phone data from the state, and you say, well, I need to get an expert to possibly look at this, but nobody will work for that rate. And did you know that? Were you having these difficulties finding an expert and looking before March 17th?
Yes, Your Honor. So I had begun, and I know this wouldn't be contained specifically in the record, but what I can recall is that during the summer of 2022, I began trying to find a digital forensics expert who could assist with the case. And I contacted every provider that I could find across the state of Tennessee, but the issue that I ran into was I couldn't find anybody who would work for the AOC rate. And I do apologize, I don't remember what that exact rate was at the time. But eventually—
I'm sure it's not much, but—
certainly not, Your Honor.
But at that point, the way you phrased it, I had a question. When you wanted to look at the other data, I guess, on defendant's phone and possibly the victim's phone, were you looking for anything specific, or were you able to identify anything specific, or were you just hoping something was on there?
Yes, Your Honor, and that kind of ties into what the court's ruling, what the court's basis for denying it. Court found that the request was too speculative. And so I can say, Your Honor, that there wasn't anything specifically that I knew would have been on the phone. What I wanted, the reason why we wanted to have the phone data reviewed is just because the court's aware everyone's life, a person's entire life is on a cell phone. And on the date of the victim's death on May 22 of 2021, the timing was very important in this case. There was events that happened earlier today, events that happened in the afternoon when the killing occurred. No one was actually present. And the only, part of what Mr. Morris, the digital forensics expert we ultimately acquired, part of what he addressed, and he had submitted a sworn statement as a supplement in support of our motion to continue. He had indicated that the state's extraction did not have any app data. And so what that would refer to is that any app that a person may use on their cell phone, whether it be Facebook, Instagram, Snapchat, there's always new ones popping up that I can't keep up with, but any app that could be used to facilitate communication wouldn't have been present in the initial extraction. And the extraction that we did receive, like I said, it wasn't like a global entire phone extraction where we could see every single text and call that Mr. Fox had made. It was just specific texts and calls relating to the phone function and the text message function that are inherent to the cell phone between Mr. Fox and Ms. Davis. And there were some other calls as well, but that was part of the issue, is that what the state had, what we had was what the state had selected from the extraction. And so really the reason why we wanted to see all of that is because we didn't know whether there was any communication. We don't know anything as far as the communications with Ms. Davison with any other individuals because her phone was never extracted. There was testimony at the trial that she had telephone calls with friends and her daughter, so there was testimony about those issues, but we weren't able to actually determine whether or not any communications did occur between Ms. Davison and anybody else, and that was the defense's. The theory at trial is that it was another individual who was responsible for the murder in this case.
But didn't the defendant admit to his presence at the scene? He just said somebody else came in the house.
He did, Your
killed
Honor.
The victim. So I'm trying to see what the digital footprint would have done if he placed himself at the scene.
And so the digital footprint would not have served to remove himself from the scene. The appellate, he did admit to that. But what we would have sought in reviewing those phones is to see if Ms. Davison had had communication with anybody else that could have potentially been involved in this murder. It also would have been important on Mr. Fox's phone to determine whether there was any evidence there of premeditation. Whether he had made any statement or indication that he, did premeditate, the killing of the victim in this case.
Well, I understand your argument with female's phone, I'm sorry, the lady's phone, but the defendant, I mean, it was his phone, so assuming, without revealing any confidence or your trial strategy, assuming he had communicated with you, you may have some sort of evidence that would have helped him on the phone. I assume if you knew that evidence, you would have put it in your request for more time, as in the digital footprint part, I understand, but hey, I communicated with so-and-so before the killing or after the killing, and this evidence would have helped me. So the defendant's phone, I mean, he knew what was on his phone, or should have, right?
Yes, Your Honor.
Okay. So would you say that your argument with the other phone is really a different argument as far as a different type of material you're looking for?
Your Honor, do you mean as to Mr. Fox's phone, as to the appellant's phone?
The appellant's phone, that's my point.
Yes, Your Honor.
Mr. Fox knew that potentially what was on his phone or what apps he used, besides some sort of silent tracking. But as Judge McMullen said, he admitted he was there, so.
Yes, Your Honor. What I would say to that point, without violating any client confidentiality, is that I, as a defense counsel, still would have wanted independent verification, and if there's something that would have been needed from that phone, I still would have needed an independent witness, such as or expert witness as Mr. Morris, to testify about it. But we were also, just to make it clear for a record, and it's explained in the brief, I believe, we also were trying to confirm the location data. Because even if Mr. Fox was present at the residence by his own admission, the exact timing of when he was there, when he left, when he came back, all of that was very critical in determining the question of premeditation. And Mr. Morris, during the trial, he did testify about some questions of reliability as far as the cell phone tower tracing that the state's expert had done. I don't want to cut this point short, but I know I'm running out of time. If the court doesn't have any other questions as to this matter, I do want to briefly address our third issue regarding the denial of request for voluntary manslaughter instruction. I have 2.5 minutes left so I'm going to have to do this kind of in speed mode. We do concede that a written jury instruction request was not made pursuant to Tennessee 40, 118, 110B. And that's my responsibility. I've never had that issue come up before. I've learned from that. That was my mistake. I do concede that we didn't file that. Our main argument, we are asking the court to engage in plenary review. If the court denies plenary review, we would ask for plain error review to apply. The basis for Mr. Fox's argument as to why plenary review should apply, the issue was raised contemporaneously in the trial court. It's contained in the transcript where the defense argues, I believe twice during the trial, for the inclusion of this instruction. Once at I believe it's at the end of the state's proof and maybe towards the end before the jury or before closing arguments. At that point in time, there was not a contemporaneous objection made to the state for the defense's failure to file the written request. Likewise, we included it in our initial motion for new trial. There was no objection. We argued it during the amended motion for new trial hearing, and there was no objection. And so we would submit respectfully that the state waived that claim by not contemporaneously objecting to it. Understanding that the court may not be persuaded by that argument, we do brief the 5 factors that are necessary for plain error review. And for the sake of time, I would rely on my brief for that. And I will say that we did file our reply brief. Once the issue was raised, we addressed it. And during every step of the trial, even if that written request wasn't filed, we took steps to try and preserve that issue for appellate review. So if the court doesn't find plenary review is warranted, we would ask for plain error review. And with the brief time I have left, I'll yield the podium to my friend across the aisle.
Good morning. May it please the court, Catherine Redding on behalf of the state. The trial court acted within its discretion when it denied the defendant's second motion to continue trial. In order to obtain relief on this claim, the defendant has to first show that the trial court's failure to grant a continuance denied him a fair trial, or that it could be reasonably concluded that a different result would have followed had the continuance been granted. And he also has to show that he suffered actual prejudice. And the defendant simply cannot meet his burden here. Counsel has gone through kind of the relevant dates, but I just point out that the trial court's denial of the motion to continue, the second one, arose from a reasonable concern about its ability to administer the criminal justice system and to control its docket. Here we have a defendant who was originally set for trial in January 30th, 2023. In October 2022, so several months before, he filed a motion to continue so that he could find experts, including an expert that would have, the expert he is complaining about the inability to conduct a review today. So the trial court then in October granted the motion to continue and pushed the trial to May 1st, 2023. So that gave the defendant more than 6 months to find an expert. From the record, it appears that counsel was not able to find this expert until April. The record will speak for itself, and my recollection of the timing is a little fuzzy, but between a week, it appeared in April, early April, it appears that the defendant filed the second motion for continuance and found the expert. And so the trial court held a hearing on that motion to continue, and what it said is, look, I'm going to preliminarily deny your motion to continue. I want your expert to see how much he can get done. And let's come back on April 25th, it's about a week before trial, and let's see where you are then. So on April 25th, the court had a hearing, and it was at that hearing where counsel kind of informed the court as to the expert's status. The trial court said, look, what you're offering me right here is just too speculative. Like, it does not appear, I don't know what information you're trying to get. I don't understand how that would help your case. And kind of to the location information, the point, I think you're right, you correctly point out, the defendant in his second version of events says, I'm at the house. I was at the house when she was murdered. His claim was just, it was somebody else. So knowing where the defendant was located isn't relevant, given that this is the defendant's position, that he's told law enforcement that I'm home, somebody comes in and kills her. We don't need to know what the location data says because the defendant has placed himself at the home. So then defendant told the trial court that Mr. Morris needed more time to determine if additional location data existed. The state said, look, we're not using the cell phone location data. We're using calls and text messages to kind of build a timeline here and establish what happened. And the court just generally found the information it was receiving from the defendant to be too speculative to warrant a second continuance. But even still, there's still the second prong. The defendant, in order to obtain relief, has to show actual prejudice. And even now, it's still speculative. The defendant alleges in his brief that there was potentially valuable information on his phone. We still today don't know what was on the phone. We certainly don't know. There's nothing, no follow-up. At the motion for new trial, there is just argument. I believe there's just argument. There's no actual an affidavit from Mr. Morris or any sort of follow-up on what Mr. Morris would have found had he had more time. And that is what the defendant has to show. It's not just, I didn't get this, I should have had this. It's, if I had had this time, this is what I would have found. This is how I was actually prejudiced. And without any information from Mr. Morris indicating what would have been located had he had those extra 15 to 45 days, this defendant just simply has not met his burden. As to the voluntary manslaughter instruction, state's position is that the defendant waived this claim by failing to file a written request for a voluntary manslaughter instruction, and that the state's failure to object or notify the defendant of his failure to comply with the rules, and the trial court's failure is irrelevant. It's the defendant is responsible for litigating his own case, and the state's failure to call his attention to his procedural deficiencies does not mean that the state has, in the trial court, waived a plain error claim on appeal. But nevertheless, the defendant is not entitled to plain error relief because he cannot establish all 5 elements of the plain error review. First, he cannot show the violation of a clear and unequivocal rule of law. Voluntary manslaughter requires the defendant to be acting in a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. But there's simply no evidence here of adequate provocation that caused the defendant to kill Ms. Davison. And the defendant certainly argues that he had adequate provocation and that Ms. Davison had just broken up with him, but there is no clear and unequivocal rule of law that says being dumped is adequate provocation for shooting and killing someone. And so, at least certainly not that I could find. But even if such a rule exists, that's not a clear and unequivocal rule of law such that failure to give this instruction constitutes the breach of a clear and unequivocal rule of law. And even if you move past that, the defendant can't show that review is necessary to do substantial justice. And I'd say that this kind of plays in, if the court were to find plenary review as the appropriate standard, this would defeat relief under that standard, which certainly the state is not conceding. But this defendant can't show that review is necessary to do substantial justice because voluntary manslaughter is a lesser included of second-degree murder. And the jury was instructed with the sequential instruction that it could only get to the lesser included if it found the defendant not guilty of the greater charge. And here, because the jury convicted the defendant of first-degree murder, it did not get to second-degree murder, much less get to a lesser included that would have included voluntary manslaughter. And for these reasons, any error in failing to instruct the jury on voluntary manslaughter is harmless. And so the defendant, for these 2 reasons, cannot establish that he is entitled to plain error relief. So if this court has no questions, we ask that you affirm. Thank you.
Thank you, General. Mr. Zinser.
Thank you, Your Honors. The difficulty in dealing with digital discovery in the age that we live in is that lawyers, we think we're smart and we know everything, but the fact of the matter is we need experts. It's impossible for us as lay people. Lawyers don't refer to ourselves as the lay people very much, but in the world of digital forensics, cell phone data, all these things, I am a lay person. And it's hard for any attorney who's in this position to know exactly what they need to look for or what they can find without the assistance of an expert. And I would submit to Your Honors, it's notable in this case when the court's reviewing, the abuse of discretion prong as to the denial of the motion to continue. In his sworn statement, Mr. Morris said that he just needed 30 to 60 days to be able to complete his work. As an officer of the court, I'm always respectful of the court's dockets and making sure that they move efficiently and that justice is administered promptly. But I would submit that when we're dealing with a first-degree murder case, when the appellant is facing life in prison, the gap between the presentment date of January 27th of 2022 and the trial date of May 1st of 2023 was not a wholly unreasonable delay.
Well, Mr. Zinser, speak to what the state just said. We still don't know we don't have an expert report.
That's correct,
So
Your Honor.
what do we
And this
do?
is this isn't formally part of the record. Mr. Morris, he sadly passed away after this trial occurred from an illness, and so we were back in a position of not having an expert who I could find who could afford to work for the AOC rate because Mr. Morris was the only one I had to begin with. What I would submit to Your Honors is that the actual prejudice here is just the fact that Mr. Fox was not able to fully develop his defense because we didn't have access to all the information that was on the cell phones. I understand that under the laws of our state, we would want something more concrete than that, as far as a showing that could be made to the court. But in advocating for my client, that is the best explanation that I can give, is that being deprived of the opportunity to even look would constitute an actual prejudice in itself. Regarding the state's contention as far as the location data not being relevant, we would submit that that is relevant, because even if Mr. Fox is there, even if he admits that he was in the residence at the time of the murder, the longer he's absent from the house, the longer that he's gone, and the record shows he left and went to his mother's house, the longer that he's gone from the house, the longer that it is before he calls 911. That goes directly to the premeditation element, because the jury is instructed that conduct after a killing can be used to determine premeditation. And so the location data is important, because we would need to determine whether the timelines proffered by the state as far as when he was at the residence, when he left, when he came back, we would need to make sure that all of that is truly accurate. And so I would submit that the location data was very important in this case, because it tied so directly to the question of premeditation. And as to voluntary manslaughter, with the jury not coming back with second-degree murder, we address in our brief. We understand the court could look to that, and it would perhaps weaken our argument. But what I would submit is that the problem when you're denied a jury instruction is that you are also denied of the ability, your ability of what you can argue is constrained. And so although there is no specific case law in this state that says words can, or break up or anything of that nature could serve as adequate provocation, it's the jury's, they're the finders of fact. It's their province to decide whether an emotional state that could result from that would have been adequate provocation. And without that instruction being included, we had no legal basis to argue it. It only could have been first-degree murder or second-degree murder or any of the other applicable lessers. We couldn't even address that question of sufficient provocation. And so for these reasons, Your Honor, we would ask the court to reverse the ruling of the trial court, and thank you for allowing us to be heard.
Thank you, Mr. Zinser. The briefs were excellent. Thank you for the excellent arguments. We'll take it under advisement. We're going to take a short recess, but I wanted to ask about General Evan. How is she doing? We got the motion to continue and sounded pretty serious, so if you know, you can tell.
She had a doctor's appointment this morning. She thought she threw out her back, and it turned out it was more serious than that, and it